I think we are just about streaming live. It is Peggy Hall here from the healthyamerican.org. I have got some good news for you. Breaking news coming out of California. Many of you probably know about it because you've been sending me emails about an injunction that came from a federal court halting this egregious, illegitimate, basically unlawful, immoral, unethical, unthinkable censorship law against physicians in California. I want to bring you up to date. And as always, I want to give you the bigger picture as to what's going on and break this down for you so that together we can speak about this intelligently with others. This is a step in the right direction. In fact, I covered this law back in October. I will leave a link for you below, and let me know in a comment if you are a doctor, if you know someone who is, if you know of any doctors that have left California, and what impact you think this ruling is going to have. Remember, it's not a final ruling. I'm going to be breaking that down in just a moment. The first thing I want to do is just give a shout out to the sponsor of this afternoon's broadcast. And I've been telling you about ketowithpeggy.com. Friends, this is a product that I personally use. I love, I trust BioTrust, and I'm grateful that they see value in my message and they want me to bring their message to you. So here we go. A recent survey reveals that if your New Year's resolutions revolve around weight loss, half of all Americans are with you. One of the easiest ways that I recommend jumpstarting your New Year resolution is with the amazing keto powder that you find here at ketowithpeggy.com. This helps you tap into many of the weight management benefits of being in what's called ketosis, even without the need for extreme carb restriction or having to go through the infamous side effects of being in ketosis. So I'm impressed because when I first started taking this, literally within about a week, I noticed a significant difference in my appetite and my cravings. So I would love for you to try this as well and experience the kind of effects that I had. So you can grab your order today for up to 51% off, and you are going to get several free bonuses. And I want you to get this before their New Year sales end. And so you can go to www.ketowithpeggy.com. I will have a link for you in the description box below. Just click that little more button. It will expand the box and you'll see the link for ketowithpeggy.com. And then you can get ready to look your best this new year. All right. Let's celebrate great news coming out of California. That's where I am. And a lot of you ask me why I am in California. I just had a really interesting back and forth with a lovely, healthy American that's in Canada. And maybe if I have time, I'll bring that exchange with you here. I also want to bring to you, oh gosh, I don't think I have it. I will do that next time. I've got so many wonderful cards and letters from you healthy Americans encouraging me and telling me how my videos have helped you stand strong against tyranny. So I want to highlight the great work that you healthy Americans are doing in your area. So speaking of great work, there are at least 3 lawsuits that came out against this egregious law in California. It is known as AB 2089-2089. That stands for Assembly Bill. Now, it's no longer a bill, so I don't like to refer to it as AB 2089. I like to call it by the actual law. So that's the law that's on the books, and we will start right out by looking at that. And I'm going to take you right on over. Let's see. I know I've got this. Okay, here we go. I'm going to share my screen, and we are going on over to California Business and Professional Code 2270. That is the actual codified law that started out as Assembly Bill 2089. Actually, right, why don't I show this to you right as well? Here is the video that I did. Look at my expression. I was flabbergasted. And that was a video that I did. It says 3 months ago, and that said censorship of California doctors will backfire. And I predicted 4 things, and I will cover those again at the end of this video, and we'll see if my predictions came true. So this is 3 months later, and I actually really love this video. It's one of my favorite videos because I have a high degree of snark. So if you do not like my snark, do not watch this video. In fact, what I think I'm going to do is have my lovely editor edit it down a little bit, because let's see, it runs about 31 minutes. I would like it to be a little bit shorter. I'm going to remove the ad and a couple of just fluff, and then I will distill it down, and I might get that up for you tomorrow as a little bit of a bonus video, because it, if I do say so myself, has a good degree of snark about how ridiculous this law is, especially when your HR department and the clerk at Trader Joe's are acting like doctors so they can give you medical advice. The clerk at Trader Joe's can give you medical advice to self-suffocate and yada, yada, yada. And your employer can tell you that you have to have a nasal assault and become a human pincushion because it's your HR department. And of course, they're medical doctors and can give you medical advice, but actual medical doctors are restricted from giving you medical advice. This is the world we are living in. So definitely this is a must see, and I will get that edited and out for you tomorrow. So let's go back to California Business and Professional Code 2270. I want to highlight a couple of things about this law. Then we will look at the court ruling, which it's not a ruling, it's a preliminary injunction. And we will talk about what that means and why it is good news so far. Okay, this is a very short law, and here it goes. It says, it shall constitute unprofessional conduct. Remember, doctors are licensed by the state, so they can take that license away. And I know probably a lot of you, like me, don't believe in this type of professional licensing, but it exists. And here is a new aspect to this license. It shall constitute unprofessional conduct for a physician and surgeon to disseminate misinformation or disinformation related to cooties, including false or misleading information regarding the nature and risks of the cooties, its prevention and treatment, and the development, safety, and effectiveness of the cootie cocktails. All right, before we go any further, that basically, they're going to define what those words mean. And this is where the judge says, hang on. These definitions are ludicrous, they're outrageous, they're vague, they're ambiguous, they will not hold up. And therefore, I am going to put an injunction, which is a halt, a stop, a big pause on this law. It cannot be upheld until the entire lawsuit has been argued and settled. So that's where we are. But let's take a look at this. All right. So board means the medical board or the Osteopathic Medical Board of California. Now, what's interesting is that nurses apparently can disseminate misinformation or disinformation without any problem, but it's the physicians and surgeons. I find that very, very interesting. All right, here we go. Disinformation means misinformation. Okay, now we're going into our circular non-logic. They really are scraping the bottom of the barrel. I think whoever wrote this law should undergo a psychiatric examination to make sure that their head is on straight. Here we go. And I showed you who wrote that law in the other video. In fact, I exposed Evan Lowe. Yes, he's very low in his dealings. And I exposed a few other things about him that you might not want to see. Keep your kids away from that video. Here we go. Disinformation means misinformation that the licensee, meaning the physician or the surgeon, deliberately disseminated with malicious intent or an intent to mislead. Okay, right off the bat, how is that going to be proven? How is it going to be proven that a physician or a surgeon maliciously, right, had an intent to mislead or an intent to mislead? That's absolutely ludicrous. Disseminate means the conveyance of information from the doctor or licensee to a patient under the licensee's care in the form of treatment or advice. Now, here's the other thing that troubles me. What about just how does conveying information, how does that equal treatment or advice? Right there, I would take issue with that, because I'm giving you information right now, but I'm not giving you any advice. My goal on this channel is to provide information, education, inspiration, encouragement, empowerment, but you decide what to do. I don't give any advice on this channel. I give information that you can then take and conclude, make a conclusion and determine what you want to do. So I think this is also they're misleading in this law. So how can information be construed as treatment or advice? I just don't see it. Here we go. Misinformation means, this is the one that really gets me. Misinformation means false information that is contradicted by contemporary scientific consensus, contrary to the standard of care. Now, when we take a look at this judge's ruling here, the preliminary injunction, he takes issue with this standard of care phrase and contemporary scientific consensus. All right, hang on. I can't go any further without making this statement. Let me know in a comment what you believe the definition of consensus is. And is that definition the same as evidence? All right, consensus is an opinion. It's a group of opinions that conclude something, but it's an opinion. It's not evidence. Evidence is based on facts. In fact, I actually brought up the definition here, and I will just share that with you right now because I think this is absolutely stunning. And then we'll go back to that law. Here we go. Evidence is a collection of facts that indicate a proposition is true. So evidence in terms of whether cooties exist or not, evidence in terms of the cocktail and its efficacy, evidence in terms of can anyone enforce any type of mandatory medical intervention on you. We would gather facts to indicate that whether that is true or not true. And that's evidence. It's facts. It comports with reality. Consensus is an agreement of opinion. Opinions are not facts. And then I also have a link here for my previous video, which I will also link for you below. So that really troubles me, and it troubled the judge, as we're going to see in just a moment. Further, a consensus can change willy-nilly. So today's consensus might be different than tomorrow's consensus. And by the way, this reminds me of the whole global swarming global swarming information that is based on consensus and not based on evidence. That's a topic for another day. But the fact is, they will come out with these amorphous, ideas that cannot be nailed down. So contemporary scientific consensus that was bought and paid for, is that what they left out of this law? Contrary to the standard of care. So you'll see that the judge and the plaintiffs are also very concerned about lumping those two together. Okay, physician and surgeon means a person licensed by the Medical Board of California or the Osteopathic Medical Board. All right, a very short law, and it all is based on the notion of disinformation or misinformation that the government is defining for you. Very, very troubling to me. Now, the good news is that out of these 3 lawsuits that were filed by different physicians with different attorneys, they were all filed in federal court, and they were filed using this cause of action. They said that it was a violation of their First Amendment right, which is the right to free speech, and then the Fourth Amendment, which is the right to privacy, which is the privacy between the physician and the patient. Imagine if there was a law that prescribed what an attorney and a client could talk about. It's actually the exact opposite. There is an attorney-client privilege where those communications are confidential. I know that because I have a relationship with a group of attorneys who are representing me in my case, which now is going to be heard on, as I'm airing this today, it's Thursday, it's going to be heard on Monday, January 30th. I did a video recently called What It's Like to Sue the Government, and I talk about everything leading up to it and how it's been delayed, and there will be a Substack coming out on this very soon. So I really feel for these people doing the lawsuit. I'm stunned that they were able to get an injunction so quickly, whereas I'm going on year 2 here in California, maybe because I'm in California court, but they filed in federal court. And let me bring this to you. Let me bring this to you as well. So they are, and I'm going to share my screen. We'll go back to the document here. So here it is. It is deprivation of rights. Many of you are familiar with this 1983, Section 1983, where you can sue any person, I like that, who under color of any statute meaning they are acting under this law, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia. So every person who subjects, causes to be subjected, any citizen of the United States or other person within the jurisdiction thereof, meaning you don't have to be a citizen of the United States to have your rights trampled on if you are here within this jurisdiction and thereof, and you are subjected to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for an act or omission, taken in such officers. Okay, we'll go on. What we're looking at is, for the purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute in the District of Columbia. All right. The most important part is right here. Anyone who says that I am doing this because the statute requires me to do so, anybody who deprives you of your rights, that is a violation of Section 1983. This is very, very commonly used with prisoners who have their rights violated, because prisoners still have rights and they cannot be treated in certain ways, yet they are. And so there are a lot of cases that are brought forward in federal court, to my knowledge, when I researched this, based on Section 1983. And then these cases were also brought, as I say, in violation of the First Amendment to the Constitution and the Fourth Amendment to the Constitution. My question is this: because this is a California statute, I'm just curious as to why it was not brought to, in the state of California using California Government Code 37100. California Government Code 37100 is very simple. I've been teaching about it for going on 3 years now. And that says that laws may be made by the legislative body in California that are not in conflict with the United States Constitution or the California Constitution. So this law, this California Business and Professions Code, let's see, what's the number of it again? 2907? Yes, 2270. California Business and Professional Code 2270 is in clear violation of California Government Code 37100. It's cut and dry. It is, all of these laws are null and void when they violate your constitutional rights, either at the federal level or in the state of California. So that was not brought. Now, I will say that because it went to federal court, it seems like it went through pretty darn quickly. And I did not bring my case under federal court or to a federal court or under federal law, because I'm not even a plaintiff. I'm a petitioner. I'm requesting the court to issue, wait for it, a writ of mandate requiring the county to follow the law in an emergency. There's a law that was written to prescribe the behavior of these legislative bodies during an emergency, and it's called California Government Code 101080, and it says exactly what this Board of Supervisors has to do during an emergency, and their answer is, well, we don't have to follow it because it's an emergency. This is the logic that is driving the attorneys for the county. Absolutely stunning. And of course, they're kicking the can down the road and they're playing hot potato with the case. But my goal, my prayer, my intention is that things will be resolved this coming Monday. Thank you, everyone that has supported me in that case. And if you are interested, many of you are asking, and I so appreciate your prayers, your cards, your notes, and you can see the link for snail mail below. And then for those that want to help me directly, there is this button right here over at thehealthyamerican.org. So thank you, everybody, for that. So let's get back to the case at hand, and I'm going to show that to you. It was important to have all of this preliminary information. So I'm going to cue this up right here. And this is actually what was released yesterday. So here we go. In the United States District Court, the Eastern District of California, and here we go. That was filed yesterday. This is the judge's preliminary injunction. So a couple of things that I wanted to point out, and these are the people that are doing the case. These are the plaintiffs. And it goes on. I will leave a link for you. I don't want to read the entire thing. It's not that long. It's only 30 pages, but there were a couple of things that I wanted to point out. And it is in the beginning here, they are just summarizing what the lawsuit was about. And then let me show you. I actually brought a couple of points that I wanted to highlight from the court proceeding. So here we go. We looked at California Business and Professional Code 2270. We read that law. And here's what the judge said. As the first and second factors weigh in favor of standing, meaning that the plaintiffs that brought the lawsuit have standing, they have the right to bring this lawsuit. The court concludes that the plaintiffs have established an injury in fact. So they are saying, these doctors are saying that they are being injured because they might be prosecuted under this law if they give any information related to cooties, related to the cocktails, related to any questions about it. So because this is a very likely injury that they will experience, and that injury can be redressed, can be stopped through an injunction enjoining enforcement of that provision. That means that this judge is halting. Enjoining means preventing them from doing it. Enforcement of that provision, meaning the law. So the physician plaintiffs have standing to challenge it. So that is one of the hurdles that these plaintiffs needed to cross in order to have this injunction go through. Now, I think this is also very, very interesting. So this is on page 25 of the document I just looked at. I will link it for you here. And what I think is so interesting is here's what the judge says. Far from clarifying the statutory prohibition, right, against disinformation, the inclusion of the term standard of care only serves to further confuse the reader. Under the language of AB 2089, I don't know why they're using that other than the actual law, which, as we know, is now Business and Professions Code 2270. To qualify as misinformation, the information must be contradicted by contemporary scientific consensus, contrary to the standard of care. Oh, here they have it right here, the law. Put simply, this provision is grammatically incoherent. While statutes do not need to be written with mathematical precision, they must be intelligible, meaning we can understand them. And this is one of the rulings that say so. It is impossible to parse the sentence, meaning break it down, and understand the relationship between the two clauses, which are contradicted by contemporary scientific consensus and contrary to the standard of care. Because the definition of misinformation fails to provide a person of ordinary intelligence fair notice of what is prohibited, and it is so standardless, I like that word, that it authorizes or encourages seriously discriminatory enforcement. It also has vagueness concerns. All right. While the definition of disinformation includes a scienter requirement, I'm sorry, I don't know what that is. I didn't research that. There is no such requirement in the definition of disinformation, which is here. Accordingly, oops, I skipped one. The provision is unconstitutionally vague. Yes, I wholeheartedly agree. Accordingly, the court concludes that the plaintiffs have demonstrated a likelihood of success on the merits of their vagueness challenges. So this means that the plaintiff said, this law is not enforceable. It is so vague, we can't even define what misinformation means. I am going to be harmed if I say something that doesn't align with what the consensus says. And how do I know what that even is? And the judge says, the judge rules, you are exactly right. And therefore, you are very likely to succeed when the case goes through. So at the very end here, let me bring that to you. Again, I will have a link for you so you can read this as you like. And it says, here we go, on page 30. All right, this was signed yesterday. It is therefore ordered that the plaintiff's motion for preliminary injunction be and the same hereby are granted. Pending final resolution of this action, defendants, their agents, and employees, meaning the government and everybody on the board, medical licensing board, and all of that, all persons or entities in privity with them and anyone acting in concert with them are hereby enjoined from enforcing California Business and Professions Code 2270. That gets a big round of applause. So to summarize, in this case that was brought forth, it's still pending. They're still going to argue this case in court. There's still going to be evidence and testimony and witnesses and a jury. And there still has to be a final ruling issued by the court and entered into the record. But right now, the plaintiff said, Your Honor, while we are in the midst of this lawsuit that could go on for years, if you're using mine as an example, in the meantime, we are going to be, number one, we're going to be harmed because we could have our license taken away. We could have this legal action against us. We don't even really know what the law means. And therefore, we're asking you to put a halt on this law while it's being argued in court. Secondly, we believe that we're going to win. It's likely that we are going to win on the merits of the case because of what they put forth. And the judge agreed that, yes, they will be harmed. And yes, it's likely that they are going to succeed. So in the meantime, there is a halt. The government of California, the medical licensing board, anyone related to this cannot enforce this law. This is a huge win for California. Remember, it ain't over till it's over. Next, what's going to happen? I predict probably by tomorrow, the government of California is going to appeal this decision of the injunction. And they're going to say, no, you need to get rid of this injunction. I promise you that is going to happen. All right. Now, I also promised you that I was going to tell you about the predictions that I made back in October. And that was in the video that I showed you previously. So I'm going to look at the list that I wrote of those predictions. Number one, I predicted that based on that law, that egregious, illegitimate law being passed in California, or the bill being passed into law, I predicted that good doctors would be leaving California. And that's exactly what's happened. I personally know doctors that have left California for, guess where? Yes, you're absolutely right, Florida. And because of that, because of the good doctors leaving California, let me know in a comment what is going to be the result of that. Just think that through. If all of the good doctors are leaving California, what does that leave us with here in California? Now, I have been so grateful to my eye surgeon who restored my vision. And I often said to my husband how lucky we are, how fortunate we are to be in California, especially in Southern California, especially in South Orange County, which is basically the hub of the top medical practitioners in the world. Some years ago, all right, people would fly to California to get the medical care here because it was so advanced and available and top notch. So I can't vouch for that being the case anymore because these doctors who are of ethical and moral standards do not want to be subjected to this and they're leaving California. What does that leave California with? The continued destruction of what used to be the best medical care. I did a video about how medical care in the United States is like worse than when I lived in Morocco, how bad it is. So that's the second prediction I made, which was people of faith, people of ethical and moral standing that actually care about what's right and wrong. And they don't just care about the consensus and they don't care about doing things for money. They're being purged from the medical profession. I know this because of the work that I've done with my husband, Pastor David, in helping people understand their rights as protected under Title VII of the U.S. Civil Rights Act, which protects your religious expression and observance and practice at the workplace. You have a right to wear a turban. You have a right to wear a veil. You have a right to request Friday afternoons off to go to the mosque. You have a right to say that I can't work on Saturday or Sunday because of your need to go to your religious observance. So it is protected by law. It has been upheld by law, but in the last couple of years, it has been trampled on drastically. And I believe that in the military, in the medical professions, in the educational settings, which frankly, I'm actually glad that we're seeing the destruction of public education, because it is not a place for your children or grandchildren to be. There are far superior learning opportunities that don't even require a penny, and they don't require you to be there. There are so many things that I've spoken about, and I will continue to do so going forward. So I believe that in the military, in the government, in the medical settings, in the educational settings, they really are purging people of faith. And how sad when you think about the medical profession. My mom was an emergency room nurse for about 40 years, and she worked for a Catholic hospital. Most hospitals were started by Catholics, and I'm talking about, centuries ago. And, I'm just stating the fact. And they also took care of the orphans, and they took care of the widows. They went and preached to people in prisons. They cared about the soul of humanity. And these were started by the Christian faith. So as a result of that, you could go into a hospital and you would see crosses, and there would be chaplains, and there would be Bible verses on the wall. And it was a place of not only physical healing, but spiritual healing. Now, I've not been in a hospital in years, but I think it would be you let me know if there are any Bible verses at the, when you go to check in at the admitting clerk or something. It's basically been stripped from its foundations, from its spiritual foundations. And I find that very, very sad. And I've mentioned it before. We have helped people keep their jobs who are atheists. And those that I've spoken with are in favor of religious freedom in this country, because why would you want to live in a country that does not allow you to worship in a way that is aligned with your soul? It's absolutely stunning. And so when you strip the medical profession of people of faith, and I'm not saying that these people who brought the lawsuits are people of faith. I don't know their faith background, but I'm saying in general, there is a trend toward removing people who have faith convictions. And I know that because they were making it very, very difficult to get their religious accommodations. So I certainly would rather be taken care of by somebody who's going to pray for me and my recovery, as well as take care of the medical and scientific stuff, than somebody who I'm just a body without a soul. That's my opinion. All right. The third prediction I made, and this is a good one. All right. I think so those are two that were a little bit dour and dire, but I've got three great predictions, and I do believe that they're coming forward. And in fact, I'm seeing them happen. So number 3, I believe that more and more people will seek out holistic alternative healing modalities. I think we're in the midst of a great medical revolution that's going to have amazing outcomes. I personally had 2, let's say, long distance consults with MDs out of California and actually I had a lovely, one of my friends here and freedom fighter, Dr. Barkey, reached out to me, and he's, I understand, still in California and one of the plaintiffs in a different lawsuit. And he, along with others, gave me some great advice in terms of holistic healing modalities for this crazy nerve pain, which I'm so grateful to say has abated. So more and more people are going to seek this out. I did not step foot into any mainstream medical merry-go-round setting. I never suffocated myself. I never subjected myself to any type of nasal assault or giving my DNA in a cup. And I certainly am a pureblood and have never consented or participated in any type of human pincushion ritual. I simply do not consent and I do not participate. So I think more and more people are going to be going in that direction, which can only be good. And I've also said it before that I have had some mainstream medical intervention in terms of my eye surgery, and I had to have prescription eye drops, which apparently, and has helped to restore my vision. So I'm grateful for certain aspects of the mainstream medical system. But I also believe that it's way on overdrive in many settings. So I think it's only a good thing that more and more people are going to seek out the natural and holistic healing modalities. Okay. Number 4 prediction I made, which is happening right now, is that lawsuits are being filed. Not only are they being filed, but they are moving ahead successfully, as I've just been talking to you about. So the right to freedom of speech, the right to your privacy, and the other law that I mentioned, that none of these laws are legitimate if they violate your rights. I mean, it's really a no-brainer. And then this was the final prediction that I made, and I haven't seen it yet, but it was a little bit of a snarky comment, but I think it's actually valid. And here we go. If this law is on the books, and this law says that it's illegal to disseminate disinformation from a doctor or surgeon to a patient, well, then why can't we go after them for saying that the cocktails are safe and effective? Why can't we go after the doctors that said you can't come into my medical practice unless you restrict your oxygen? Isn't that medical misinformation and disinformation, that no access to oxygen is healthy for you? How about undergoing a nasal assault when you don't have symptoms, using a type of, I'll just say, protocol that has never been approved by the FDA, or a protocol that has never been, how do I put it, determined to actually do what it's supposed to do? For cooties, how do I put this, that has never actually, let me just find the words here, been found as the way they said it has been. I'll just put it that way. So why can't this law be used against all of those, all y'all out there that are not allowing people to get their diagnostic testing, to have their surgeries, to be seen in the doctor's office without going through all of this other stuff? Let's turn the tables on the tyrants, shall we? Yes, we shall. All right, friends, signing off for now. Thank you for sharing this video, for liking this video, for resubscribing. We are at 169,000 subscribers. I value each and every one of you. A big shout out to the moderators, to all of the healthy Americans that can read between the lines. Oh my goodness, there is so much information coming out again and again and again that requires us to be on our toes and to read between the lines so that we can continue to expose the evil, to fight against this tyranny, and to encourage each other, because you know what? You're doing great. I like this word, oodles. I have oodles and oodles of information that can help you with your medical rights, getting your medical care without discrimination. I have some very recent videos. I have a lot of videos that I've done over the years. They all are still valid. So I encourage you to study up on your rights, to be prepared, and to stay healthy. That's my hope and prayer for you as well. So thank you, everybody, for being on board. I will have a video queued up for you tomorrow, and I always look forward to seeing you here. Oh, I forgot to tell you, I've got this amazing Substack that I want you to read. And here it is. Final thing. Shoot, I was going to tell you all about it. Well, it's better for you to read it, I think. So let me share my screen, and you can go to peggyhall.substack.com. I have it linked for you below. And here you go. This is it. You're going to click on this article, Judge Grants Preliminary Injunction Against California Censorship Bill, AB 2098. And here we go. I might change that. Well, everybody's looking for the AB 2098, but as you know, it's also California Business and Professions Code 2270. That is the law that we have to strike down. So I hope that you will read this. There's a lot of great information about what an injunction is, what it means, what exactly happened in that lawsuit. So I will have that for you, and I hope that you will read it and share it and comment on it as well. You know, the Substack is fantastic because for those that want the written word to dig into, and it's easy to share, and you can highlight and underline and take a little bit longer time to research and analyze. And I want you to read between the lines, and I want you to point out if there's something I missed or something else that I need to look at, because that is how we continue to develop our skills of critical thinking. And that's exactly what the bad guys, the evildoers, the hogwashers don't want us to do, is to engage in critical thinking, because otherwise we pull back the curtain and we show them that the emperor has no clothes. How do you like that mixed metaphor? Okay, I'm going to leave you with that, and I will see you very soon in an upcoming broadcast.